Good afternoon. Welcome to another training session by Call for Justice with United Way, Greater Twin Cities United Way 211 in Minneapolis, Minnesota. My name is Krug. I'm the Executive Director of Call for Justice. One of our general mission is to connect low-income people with civil legal resources. One of the ways we do that is by training United Way 211 on how to make targeted legal referrals to various civil legal resources in the Twin Cities and Greater Minnesota. Today, we are revisiting our very first training session that took place in March of 2012. That session was on the basics. And today I'm coming back to give us a little bit of a refresher on the basics. What's the difference between a civil and criminal case? How does a criminal case progress versus a civil case? How do resources get allocated in the civil context? And generally, things for folks to know. And today we'll be training on a brand new topic relative to how to help direct what are called low bono clients to low bono resources. So I'm happy to be here again. I will try not to be too much of a boring talking head. I'll try to be a lively talking head. And everyone in the room can count the number of times I run my hand through my hair. So let's see if we can make 50, okay? We can take some bets on that. All right. So beginning with the basics of all things, I want to talk first about the difference between civil and criminal. All right? And the backdrop of all of this is something that I'm going to take you back to your history lessons, which is the United States Constitution. In the Constitution, there is a provision about not depriving someone, it's Article whatever, I'm glad this is being taped, that says that a person cannot be deprived of life or liberty without due process of law. And that constitutional principle actually forms the foundation of everything that occurs in the criminal context and some that occurs in the civil context, but not nearly as much. But the idea and the fundamental difference between criminal over here and civil over here is that on the criminal side, we are literally talking about individuals who face the risk of losing liberty. That is, losing their ability to move around, to not have to be confined to a jail cell. And because liberty is so important to Americans and humans in general, the Constitution and all kinds of laws built on the basis of the Constitution are geared towards protecting the process by which somebody could lose their liberty. Over on the civil side here, the issue usually is not liberty, it's usually money. Or it's being ordered to do something with your property or with your person that you ordinarily would not do. But for the most part, almost 99.9%, the civil side never, ever, ever involves the risk of loss of liberty. The one asterisk there is where you have a civil case and you're in contempt of the court. One of the remedies the court has is to deprive you of your liberty in order to induce you to do certain things. For example, a classic case is a reporter who won't disclose their source, and they're subject to a civil case in terms of being compelled to come to the court and disclose your source for some issue relating to national security or something like that. The reporter refuses to do that, and the court can then hold that person in contempt, and they can end up going to jail. But those are relatively rare instances. There's sometimes an issue about child support and going to jail if you haven't paid your child support and you're in contempt for that. That's another example. But going back to the difference in this liberty thing, I'm going to talk about how civil cases and criminal cases get started. So, on the criminal side, who here can tell me how a criminal case gets started? 10 bonus points if you. Any takers? An arrest! Good job. That is exactly, bing, 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 bing. Yes, it's exactly how it happens. Sometimes there's an indictment and the county attorney says, or the city attorney says, come on down to the jail, fingerprint you, and then we'll release you after that process has been done. But technically you're still in the confines of a law enforcement authority. But usually a criminal case begins with a police officer or somebody with law enforcement arresting powers. And what is arrest? The word arrest, it's to stop. And so with a law enforcement officer intervening to enforce the law against someone and causing that person to be in confinement, could be first in the back of a squad car, then into a holding cell, then into a jail. And all of that is about, your liberty has been deprived at that point. And the question is, has it been done with due process of law? Has it been done in a fair way? Many people who have been arrested probably wouldn't consider that to be very fair. But remember, we've got this, we watch it on TV and we're familiar with the idea of Miranda rights. Miranda rights, you have the right to remain silent. If you give up that right, anything you say may and will be used against you in a court of law, all right? And then the second part of that is if you can't afford a lawyer will be appointed for you. Somebody remember to remind me to come back to that lawyer part, okay? But the first part about, not being reminded that if you say anything against yourself, that it'll be used against you, that's due process. That is putting people on notice that they have certain rights, that they have the right not to waive those rights. And if they don't waive those rights, then the government has potentially a much more difficult case to make against somebody versus they get arrested and within 5 minutes of being in the cuffs, they say, okay, I did it. That makes the government's job a whole lot easier. So, and of course the lawyers play with, well, did they say I did it before they were given their Miranda rights versus did they say I did it afterwards? That is the critical difference about due process. Is that people can waive their rights, they can confess, but due process requires that that confession happen in a certain way, in order for the state to fulfill its obligations about protecting its citizenry under the Constitution. Everybody with me so far? Feel free to ask me questions as we go along, okay? I probably won't be able to answer them, but ask them anyway. Yeah. All right, so that's how a criminal case works. Over here on the civil side, all right? There's the concept of torts. So a tort is a civil wrong committed by one person against another person or a group of people, or committed by a group of people against another group of people. A tort, in many instances, is in the context of a personal injury. So Natanya will have rear-ended me. Okay, I'm driving down the road on 494 and for some reason there's a car ahead of me and I stop in time and I don't brake them and Natanya is checking her phone because she's looking for a hot date. And so she looks up at the last minute and then Tanya's vehicle smashes into the back of mine. And I have suffered whiplash as a result and my car has been damaged. All right, you with me so far? Okay, and I like to pick on Natanya, so it's all right. I'm sure that Natanya wouldn't do that,
Has done it in the past.
Oh, has done it in the past. Okay, all right, now I didn't give you the Miranda warning before you gave me that confession, but we'll go with it, okay? All right, and so a civil case essentially really begins with what just happened. Now, whether that forms the basic. I guess the equivalent would be over here on the side before somebody gets arrested. An arrest usually starts with a crime. All right? This car accident that we just talked about would be the tort. That would be the event that forms the basis for a civil case. And so when over on this side, we have a police officer who acts with force of law to detain someone, to arrest them. Over on this side, We don't need police officers. There's no risk of loss of liberty. There is a risk of loss of money. And so the system treats things a little bit differently. And so on this side, there need to be still procedural safeguards. Underlying those, deep underlying those, would be the Constitution with a sense of fairness. So remember, not deprived of property in a certain way. But I will tell you the constitutional bond is much stronger over on the criminal side than it is over here on the civil side. It's far more nebulous in a variety of ways. And I can't go into all why that is, but okay. So in the case of Netanya and our civil case, a civil case starts with a document called a complaint. And that document is written out. So I would write out a complaint. I would say that my name is Ellie Krug, that on such and such date I was on I-94 minding my own business, and then through great negligence and disregard for care and custom and practice, Netanya, her car collided with my car. And then I would say that I was hurt as a result of that. I'd be writing all this out. And then I would say that as a result of being hurt, I'm entitled to money from Netanya. And in some states, you can specify how much it would be, and I would claim $1 million. You know, in other states, you can't say how much it would be. You would just say fair and just compensation. And then I would sign that, or if I was the lawyer for me, the lawyer would sign that. And then, though, we have to do something significantly different. So I couldn't just go and give this to Netanya. I couldn't give my lawsuit to her. I could do that. I could do it to scare her, but legally it wouldn't be effective. So what instead I would have to do is get Carlina, hold on, take that. Carlina, then you need to give my lawsuit to Netanya, okay? And then now what happened is Carlina has been my process server. She has been my person who formally has served Netanya with the lawsuit. So back here over with the arrest, it formally starts with the police officer detaining somebody. After that happens, the state gets involved to determine whether the arrest was warranted, and if the prosecuting city attorney or county attorney believes that it was warranted, then they file a criminal complaint, right? But they don't, hello, come on in. Have a seat. But they don't have to over here with the criminal complaint, they don't have to serve anybody because they've already got the person in custody. On this side here, because we want to have a civil system where we don't have people just willy-nilly giving people lawsuits, we have to file a formal process. And so Carlina was my process server, and there are people out there that are professional process servers. The sheriff can act as a process server. They'll charge you for that, but the sheriff can do that. And I could actually ask Carlina to be my process server in real life. I could say, I want you to serve Netanya, because you'll work with her and you'll be able to get her, you know? Because with process serving, sometimes you can't find the person that you want to sue, and that causes other issues. But I could get Carlina to do that, even though she's not trained. What Carlina would need to do is to file an affidavit that says on such and such a date, I ran into Netanya and at such and such a location at such and such a time, and I hereby certify that I gave and swear that I gave her a copy of Ellie Krug's complaint. And that in Minnesota would be sufficient to get a lawsuit started. And in most states, that's sufficient. But the wrinkle in Minnesota is, so Tanya, what are you looking at? It's a bunch of handwriting, right? Okay. In Minnesota, that could actually be my complaint. It doesn't have to be any specific form. It can be written out, just like I've done right there, although it doesn't say I'm suing Netanya in that. I wasn't so thoughtful. It does not have to be filed with the clerk of court. It does not have to have a judge's signature on it. It does not need to have a court case number on it. It doesn't need a stamp or a seal on it. all I have to do is write it out, have Carlina give it to Natanya, and guess what? Natanya has been sued. And that is called, in Minnesota, it's called pocket filing. There's only one other state in the United States that allows pocket filing. Anybody else know where that is? Louisiana. Does that make us happy? And so thanks, I'll take my notes back. Thanks, Natanya. And so, yes, Melissa.
Okay. So I have a question, because this happened to me before. So when I was an advocate, right, so the abuser had the sheriff to serve his wife. So this is where she was at shelter. But, we can't confirm or deny if someone's there, so they gave it to me because I was her advocate. But I didn't take it. So let's say I did take it. Would that be considered her served?
Well, it depends. So lawyers are famous for saying it depends. So I'm just going to say it depends. And my belief would be because she's in a residential facility, all right, and it is not open to the public, but you're acting as the agent of the residential facility, that would mean you're acting as her agent, that yes, it probably would be good service.
So let's say I was being served and they came to my house and my dad answered the door and he took the papers. It's still considered?
That would be sufficient, yes, because most service statutes say either the person directly or to their last known address.
What if they deny it? I denied it when the sheriff came. I was like, I'm not taking that.
That's if the sheriff brings you the papers and you say, I don't want the papers, again, it depends.
Okay.
But I think with the shelter, it's a little bit more tricky,
Right.
and I don't know. But with your dad,
Yeah.
too bad. Here are the papers. Your dad says, I don't want them. What the sheriff will do is just leave them on the stoop or in the doorway and say, here you go. Here are the papers. You have now been formally served. So yes.
What about certified mail?
Certified mail, great question. So, certified mail is possible in federal court, but there's a procedure that you have to follow. And in federal court, you have to actually file the lawsuit if you're filing it through certified mail. Okay. In Minnesota, I don't think we can do certified mail. I'm pretty sure that we cannot do that.
Because my ex he's a landlord, and apparently if you want to evict someone, you can do that by certified mail. So
that's a little bit different because that's under the tenant statutes.
Okay.
All right, and the certified mail signature would represent that wherever it's going, the person in theory who is supposed to get it signed for it. But that's a little bit different because that's landlord-tenant. So, but with Natanya, with Natanya. Because we are strangers, so under the landlord-tenant, they have a relationship already. They have a contractual relationship. Okay. We're strangers when you ran into me, right? I don't know you. So we want to have procedures where if we're going to start a lawsuit, that she's aware of that, okay? All right, and Melissa, what did you say you were going to remind me of?
Oh, was I supposed to remind you of something?
Yeah, never mind. That's okay. That's okay. I said I was going to come back to something. I said make sure I come back to it. Yes?
Do you want to talk about the right to a lawyer?
The right to a lawyer. Yes, I do want to talk about that. Thank you. Okay. Don't worry about it. All right. All right, so let's regroup where we are. So over here we've got our arrestee. We've got the county or the city attorney giving him or her a formal complaint. And that formal, essentially, we have the arrest the next day, or if it's on a Friday night, on Monday, the arrested person, if they haven't bonded or bailed out, has to appear for initial appearance. And that's where they are charged with the crime by the county or the city attorney. The complaint may or may not be filed at that point, but they're told of what the charge is. And at that point, remember that due process stuff? At that point, there's a judge or a magistrate to face that person and say, you've been arrested. This is what happened. Depending on the level of charge, they may ask them to plead. If it's a lower charge, maybe not. Usually what it is it's an initial appearance, and they say, okay, we're going to set a date for you to come back and enter a formal plea. But at that point, they're making a decision about liberty. So that's where the magistrate and the judge will say your bond is X or Y, or there are systems around where people from the court system will make a recommendation whether that person should be released on their own recognizance. And the idea is, if they aren't a flight risk, and if they're not a risk to society, it makes no sense to keep them in jail. Send them home so they can work and go back to what their lives are and start saving the money for that big fine they're going to have to pay. All right? So, but again, that's all procedural. That's about protecting somebody's rights. Over here on the civil side, once Natanya has my lawsuit, okay, there she is. When she has my lawsuit, a clock starts ticking. And that is the time within which Natanya has to respond to the lawsuit. So it's just like, anything else in life. I do something, you have to do something back. I do something to you again, and you have to do something back. And if you don't do something in response to me suing you, then you start to lose rights. So remember when we're on the phones and we have somebody who says, I've got this paper, I don't know what it is, but it looks like I have a court date. Remember, the words to them are, you need to pay attention to what that date is, and you need to find a lawyer or be able to talk to a legal professional. The whole reason for that is because if they don't do what they're supposed to by a certain date, they lose certain rights. So right now, Natanya has 20 or 30 days, depending on the jurisdiction, to file an answer in response to this lawsuit. And by file, under Minnesota's pocket filing laws, she could actually mail it back to me, and we still don't have to go to court yet. We still don't have to file anything with court. We don't have to. The wonderment of having pocket filing, and not that I'm a fan of it, just for the record, is that you don't have to pay a filing fee. So when I did this, Carlina, you only charged me $20 to. No, actually, you didn't even know you could charge me. So you just did that as a favor to me, okay? And so right now, we're still outside the court system. But under Minnesota law, you have an obligation. And if you don't answer, and an answer can be, so Natanya's answer can be, yes, my name is Natanya. B, no, I was not negligent. C, no, you really weren't hurt because it was just a fender bender, really, okay? And D, you're not entitled to get any money, and I will defend myself fully on this lawsuit. And then you can just mail that to me, all right? And then at that point, I can send you some written questions, which are called interrogatories, and we can go back and forth for a while. But under Minnesota law, if Natanya doesn't answer the lawsuit within 20 or 30 days, or if you don't do some other things in response to what I do, I can then file the complaint with the court, pay the filing fee, and then now it's official, this lawsuit is going. And by doing that, I now can get the rights of the court, the strength of the court to help me relative to my claims against Natanya. Everybody with me so far? So over here, due process. We've got the court system, and I'll come to the lawyer in a second. And thank you, Em. Remind me to do that. Okay, over here we have all this whole process geared about protecting liberty, and if you're going to lose it, it's going to happen in a way that's technically fair. We can have that debate for a long time. Okay, over here about money, we have a process where we can seek to get money from another person, but we can't fulfill that goal without getting the court system involved. And in Minnesota, we can go to a certain point without getting the court system involved. And so if, let's say Natanya doesn't answer, let's say she just ignores it, I can then file the complaint with the court, pay the filing fee, and then I can ask the court for a default. And that's where you not come in. And then usually the court will say, have you told Natanya that you're going to file for a default? Again, because the system needs to be fair, we want to be fair to you. And if I say, no, I haven't, then the court's going to say, well, we're not going to give you a default judgment. unless you tell Natanya that this is where you're at, and you give her a chance to come back into the courthouse to answer and say why she didn't answer the lawsuit. Sometimes people don't actually get served. Sometimes it's Natanya's twin, Satanya. Or sometimes, the process is faulty, or Natanya gets sick and she's in the hospital and she can't, she's in there for 30 days and can't get out. The court would take that into account. And so let's assume Natanya hasn't answered. I go to the court. I say, yes, I've given her another opportunity to come, and she hasn't. And the court will then say, okay, Ellie Krug, get on the stand. Tell us how the accident happened. Tell us how badly you were hurt. And then we will make a decision about awarding you money. So instead of $1 million, I might get 100. No, something like that. But the court makes that decision. There's process involved with that. It's not like I can go, although if we're in certain jurisdictions in the country, I can just go and I know the judge, and no, I'm being very facetious. So the court will make that decision, and that's about fairness. Now, if Natanya has answered, we go back and forth, and we're not getting anywhere, then I can file the complaint, and then the case is now covered by the court system. They'll schedule a trial, and then eventually we will have some kind of a trial that will decide whether Natanya was, quote unquote, negligent or at fault. All right, everybody with me so far? Okay, so lawyers. That's what this whole thing is all about. I just gave you the foundation, but the whole thing is about lawyers. So over on this side here, because of this liberty thing, in addition to making sure the police give you your rights when they arrest you, in addition to bringing you before a judge or a magistrate with reasonable speed, and that you're not languishing in some jail cell for 2 months before you get to see somebody on the judiciary. In addition to all of that, the United States Supreme Court has declared that a person who can't afford a lawyer should have the right to a lawyer. And so now we're on that second part. That's what this was about, the second part of the Miranda warning, which is if you can't afford a lawyer will be appointed for you. And the whole idea behind that is that lawyers make a difference, and that lawyers can protect rights. And so who in the room can tell me how many years it's been that that under United States law you're entitled to have a lawyer if you can't afford one for most crimes that you're charged with? How many? Have any takers? Has it been over 100 years? Has it been over 50 years? Has it been 10 years?
Since the 60s-ish?
Teresa gets the gold star. Very good, very good. And so it is since the early 1960s, and it involved a case by the name of Clarence Gideon, who was arrested, I believe in Florida, but somewhere in the South, and I believe for burglary, who did not have a lawyer. And there was no right to lawyers at that time. And Gideon did something fairly remarkable, which makes me proud about being a lawyer and being part of the legal system, which is he wrote a handwritten petition to the United States Supreme Court. And he said, this isn't fair. I should have been able to have a lawyer. And so I think the ACLU got involved. Don't quote me on that, but other organizations got involved on his behalf, and then incredibly, some states got involved on his behalf. The attorney generals of several states ended up filing briefs in support of Gideon. And can anybody tell me if they know what one of those states was early on? Minnesota. Walter Mondale was the attorney general, and he signed on to support Gideon's application, and Gideon's pushing the idea that there's a right to counsel in criminal cases. The Supreme Court eventually agreed, and from that point on, the criminal defendants in most cases in the United States, if they cannot afford a lawyer, and that is through an affidavit of indigency, and those are handled in a variety of ways in a variety of states, but essentially, if you can't afford a lawyer will be appointed for you. And this is where we get our public defenders. The public defender system is an outgrowth of Gideon versus Wainwright. I mean, there were public defenders before that, but certainly today's modern system is tied into Gideon versus Wainwright. All right? And so, as we know from calls that 211 has gotten, most of the time your callers are calling and the question is, I'm a criminal defendant, I don't have a lawyer, and our referrals are to the local public defender. Sometimes the calls are, my public defender hasn't returned my call, and or I don't like my public defender. And then the referrals should still be back to the public defender's office and telling them to talk to a supervisor, and if they call you back a 10th time and they say, nobody's being responsive to me, I think then at that point the call should be the Office of Professional Responsibility in Minnesota. That's the office that governs lawyers and lawyer behavior. And I don't have that. I will get that if you need it, to you guys. But that's where, at the 10th time that lawyers have an obligation to be responsive to their clients. That obligation does not go away if the lawyer has too many things going on. Now, no, a lawyer is not obligated to return a phone call within an hour of you calling that lawyer, but they certainly are prohibited from ignoring your phone calls for a week or 2 weeks or 3 weeks. That is not acceptable. If you're no longer the client, well, that's different. But if you're the client, lawyers have an obligation to be responsive. All right, criminal side. Over here on the civil. Okay, poor Natanya being sued. Now, if Natanya has car insurance, okay,
That was my question, right?
if you have car insurance, one of the values and benefits of car insurance is that the automobile insurer will provide you with an attorney. It's called a duty to defend. But that duty, so over here, this duty to get a lawyer, to provide a lawyer to somebody, constitutional. The Constitution requires it because of that liberty thing that we've talked about before. We don't want to deprive somebody of their liberty. Over here, assuming Natanya has insurance, the obligation to provide a lawyer is contractual. Natanya and her insurance, Acme Insurance Company, have a contract. So in exchange for Natanya giving them exorbitant insurance premiums, they have obligations to her. One of those obligations is if she gets sued, not to run away. That obligation is for them to stick in with you. They could cancel your insurance, but that does not mean they cannot cancel your lawyer. Okay? So the obligation to defend is greater than the obligation to indemnify, believe it or not. And so if Natanya has insurance, one of the very first thing you should have done when we had our accident was you should have called your insurer, right? Everybody knows that. But then the second thing, when Carlina served you that paper, after getting over shock, then the next thing you should do is call your insurance agent and say, I've been served. And what the insurance company then would do under that circumstance is they have their own internal process for appointing attorneys that they contract with, and then you would get a phone call from an attorney's office saying, Natanya, I'm Sally Schmo, and I'm going to be your lawyer, and why don't you come on in and we'll talk about this. And that all has to occur before that 30 days is up. So that's what the insurance company is obligated to do. Now, on the 29th day, you may get that phone call from the lawyer, or on the 29th day, the lawyer may call up me, who sued you, and said, I've just got involved with the case. I know the deadline for answering is, tomorrow. Can you give me another week in order for me to talk with Natanya so that we can get an answer on file? And that happens very routinely. And if I had a lawyer, my lawyer would say, of course, you can have another week. I mean, usually that's the way it works. And then sometimes the lawyers say, is it okay if we don't answer while we try to negotiate a settlement of the case? And so my lawyer would say, that's all right, let's just put it in writing. And then there wouldn't need to be an answer on Natanya's behalf unless the settlements fell apart and we weren't going to go anywhere. And then my lawyer would say, well, it's time for you to answer. We need to progress towards a trial. And so there you go. Okay? But let's assume Natanya doesn't have insurance. We've gotten those calls, right? And so if Natanya doesn't have insurance, then we get into a different situation. And so then the first question is, Natanya, do you have money for an attorney?
No.
Out of your pocket?
No.
No, you don't have money. And so in that situation, the critical thing is, can anybody tell me what the most, even if you don't have an attorney, what's the most critical thing for her to do? Once Carlina has served her with the papers. To respond. That's the most critical thing. So for her to get some response back, because that way the system will know, even though it's not filed with the court, the system will know that you care about this. And at that point, your rights will start to get protected better. So, I mean, getting served is part of protecting your rights. All right, so now we're on the civil side. We're involved in a lawsuit about money that Natanya doesn't want to give up. Maybe money that you don't have, but you have a job, don't you?
I do.
You do have a job, and you know what that means.
My wages can be garnished.
That your wages can be garnished. So if you don't pay attention to me up here, okay, and I get a court to say, okay, Ellie, you get a judgment for $10,000 because it was a really bad whiplash and my car had a special paint job, okay, I can then come to your employer, serve them with papers relative to garnishment, and I can start getting your wages. Now, there's statutory limits about how much I can take, but if you want to keep a job, I get to garnish your wages, or if I know where your bank account is, I can go garnish your bank account. So, all messy, not pretty stuff, okay? And so the key when we get our callers and somebody's been sued and there's a clock ticking and there's a deadline, the key is talk to a lawyer, pay attention to that deadline. That is not legal advice, by the way. That's just common sense, all right? If you start saying, well, you need to answer and then say this in the answer, that's legal advice. But the fact of saying, you've got a deadline and you need to talk to a lawyer and you need to pay attention to that lawyer, that's good stuff. That's good 211 stuff. And that's good call for justice stuff. That's what we're teaching you. All right. Everybody with me so far? Okay, let me just check the time without tripping over the cord. Okay. All right. All of what I've been talking about now has been the difference between criminal and civil. And what I want to do is I want to move over and talk now about poverty law and the concept of the justice gap and what we've been training on for, this is the 23rd training, believe it or not, for 211. And you guys are still enjoying it, right? Not tired of Ellie, Krug, and Emily yet. Okay. All right, so what is poverty law? Poverty law is the area of representing and assisting people who are at risk of losing basic needs and basic necessities. So that would be shelter, personal safety, access to key family relationships like children or grandparent rights, something of that nature, access to health care benefits, access to government benefits. These are the basic core necessities that we as a society feel that people have a right to be able to have access to and to enjoy. And so, Natanya, I'm really sorry to report to you that $500 and you being at risk of being sued are not at all within that category. So you're not in even though you may feel you're in poverty, you're not in poverty law, and your access to the systems that I'm going to talk about next are greatly, greatly restricted. Okay? But will you write down and come back to me on low bono? Okay? Because we'll come back to that in a second. All right. So on poverty law, I want to go and discuss how the justice gap works, and if we can go to your written materials that have the pyramid. Okay? And so at Call for Justice, we've come up with the concept of the pyramid of legal resources. And we have our little fellow down there climbing the pyramid, and that's to be symbolic of how difficult this whole system is. And some would say, how unfair. Okay? But today we can't talk about fairness or unfairness. We can just talk about how it works. So, underlying all the pyramid of legal resources is the federal poverty guidelines. You guys start learning about the federal poverty guidelines from the first day that you start with 211, right? And so, and if, let me see here. So, federal poverty guidelines, well, let me back up. There are far too many people of in legal need compared to the number of lawyers that are available to serve them. So there's one legal aid lawyer for 3,600 some odd people, low-income people in legal need, and there is one private practice lawyer for 360 some private practice attorneys or private practice clients who can pay their fee. And so there needs to be some way to funnel, some way to ration out the lawyers for low-income people. And what's become that fashioning that funneling are the federal poverty guidelines. And so, anyone know how old the federal poverty guidelines are?
About the 70s?
No, actually about the time that's Gideon versus Wainwright came about. The federal poverty guidelines are a product of President Johnson's war on poverty. Unfortunately, at the same time, he was involved in another war. But the guidelines were a way of trying to at least create a base, level playing field where from state to state, everybody could understand what poverty was, what constituted poverty, and where were you above it. Unfortunately, for the most part, the guidelines are the same in Iowa as they are in California, as they are in New Hampshire or Florida. There are differences for Hawaii and for Alaska, but for the most part, and we all know that the cost of living are far different in all of those states, and that's the way it has been from the 50s. But nonetheless, we have to have some way of funneling, some way of rationing, and the guidelines are that. So, let's go back to our pyramid. At the pinnacle, at the top of the pyramid, is what would be people who can afford to pay for lawyers on the paying side, and on the nonprofit side, so on the poverty law side, draw a line. The bottom of the pyramid at the top, the bottom line between the green and the blue, that is 100, for the most part, 187.5% of the federal poverty guidelines. So, for the most part, in Minnesota as well as across the country, your ability to obtain full representation from a poverty law lawyer, somebody through legal aid or through another nonprofit legal provider, to have full representation is pegged at 187.5%. So for a family of 4, that would be $45,469. For a single person, that's $22,009. That's the top. And so people below that qualify for full representation. People above that, for the most part, can't. There are some programs that will provide full representation at 200% of the federal poverty guidelines. And so for a single person, that's $23,540, and for a family of four, $48,500. That's 200. But after 200, absolutely almost never full representation for anyone. And what does full representation mean? So, let's begin with, go back to Netanya, assuming you could qualify, but you can't, but I want to just work with that anyway, okay? Full representation would be Netanya coming to me with the complaint and saying, I'm scared about this, I don't know what to do with this, will you take care of it? And full representation would be from that moment when we had that conversation all the way down the road until we had a trial and a jury found either for you or against you, or we had a settlement where we worked out a deal where you or your insurance company pay X, Ellie Krug takes Y or takes X, and then it goes away. That's full representation, so from start to finish. And in 1982, when I began practicing as a lawyer, that was the only way lawyers could operate. I could not bring Netanya in, start with her lawsuit, and then say, well, I'm not going to represent you anymore. Even though Netanya would say, well, I will pay you. Unless there was you were presenting me with some ethical issue or something like that, I could not abandon you. I couldn't stop representing you. And that was 1982. Because of all of this poverty law, because of the number of people, the pressing number of people who have legal needs now who can't afford them, the legal system, thankfully, has responded to that. So now we have a system where, if we go back to our pyramid, today, lawyers can do what's called unbundled service. So that's brief service and brief advice. What does that mean? That means where I am a lawyer, I go to a clinic, I've set up shop, I wait for people to come in who have legal needs. So Netanya, you could come to me with your case, and I would be able to give you advice. I'd be able to say, well, when you, Netanya, fill out the answer, you should write in it that Ellie Krug was negligent back in causing the accident because she stopped too quickly. Although that's not necessarily going to work very well, but that's legal advice. But my brief service to her would be over after a half hour. And Netanya would leave. She'd be on her own to figure out how to get the answer put to me. She would figure out you'd have to figure out how to navigate the court system on your own. But my obligation would be ended and would have ended ethically. I wouldn't be at risk of being called up on that by the Office of Professional Responsibility. So that was brief advice. Brief service would be Netanya brings that to me. I answer it for you. I fill out the answer and I say, here you go, Netanya. Now go take that and you can file it, but I won't see you again. So I've done brief service. Again, fulfilled my responsibilities. I've helped you a little bit, right? But I haven't helped you 100%, correct? And you would want me to help you 100%, right? Okay, there's that rationing. There's how rationing works. And so, where are we at on brief advice and service? So, the blue would represent somewhere between 187.5 to 200 on the federal poverty guidelines to 250 federal poverty guidelines. Maybe up to 300, depending on the program. But for the most part, most programs are stopping brief advice and service somewhere at around 250. And so, important to remember. The thing about 250 is under the federal poverty guidelines. Now my eyes are getting fuzzy. So 250 would be for a single person. Oops. I guess my guidelines only jump between 200 and 300.
250 for a single person you want?
Yeah, 250%. Do you have it on yours?
For one person is 29,425.
Okay, so 250, Single person, 29,000. And then how about a family of 4 at 250?
60,625.
Okay, 60,625. Now, people seeing this video may think, well, $60,000, that's for a family of 4, that's, pretty good money. And in some locations, it is pretty good money. But in other locations, trying to raise 4 kids on $60,000 is very restrictive. But again, we're back to funneling. So, nonprofit legal providers make decisions all based on what the income is.
I have a question.
Yes.
Okay, so these are without taxes, right? I mean, because I've gotten those questions a lot, obviously, that it's like, well, I know it says that I make 60,000, but really what I take home is, and that doesn't matter, right?
Okay, that's a great question. What about taxes? What about expenses? What about extraordinary expenses? And all I can just tell you is that different legal providers have different calculations. Mm-hmm. And that's, an important rule. 211, our answer back is, I can't tell you, need to call the program, let them explain it to you. We don't want to make any assumptions about that. But what we do want to do is identify the potential legal agent for, the referral for whoever this person is. Okay? Great question. All right. So, I wanted to also just remind you about what I've just been talking about, the ability to talk to a lawyer, the ability to get some service from a lawyer. The broad concept of that is legal access. That's what that is. Legal access. The phrase access means nothing other than the ability to connect with a lawyer or a legal professional to assist with your legal need. And we have some folks here from Tubman. Tubman does a wonderful job about helping to give people legal access. You have clinics for folks, you have lawyers on staff, you have survivors who come to you, and you help those survivors. You help them with personal safety, one of those basic necessities that we talked about. You help with shelter, one of those other basic necessities. All of that is geared to helping give people access, and the concept over here about access is trying to make up, for me at least in my head, all over here we're always trying to make up for the fact that we don't have this key constitutional right about losing liberty, and that society in many ways, now I'm on a soapbox, thank you viewers, that society in many ways doesn't get it that for many people losing your apartment and having you and your kids out on the street is far more consequential than you facing a $100 fine for a shoplifting charge. But over here, we'll give you a lawyer. But here we won't. And so that is critical. Now, remember I talked about how the right to a lawyer in a criminal case was based on Clarence Gideon. There is a concept and there is a movement across the United States called civil Gideon. And that idea is that everybody at risk of those basic necessities that I listed, shelter, personal safety, et cetera, that they be given an attorney, that society provide them with an attorney in order for them to protect those rights. Now, in New York City, you will not go through housing court without a lawyer. So you have the right to have an attorney if you face an eviction. In Massachusetts, they're experimenting with the same thing. In other states, they have pilot projects providing lawyers around landlord-tenant law or relating to orders for protection. In Minnesota, there is talk, and I'm involved with those talks, about providing attorneys across the board in the state to order for protection petitioners so that they don't have to face their abusers without a lawyer involved. The problem is that it's money. Lawyers cost, they cost something, and there's a variety of ways of fashioning that if you think about it, it may cost $300 for a lawyer to be in a courtroom with somebody to help protect them against an eviction. The cost to society of not providing that lawyer for $300 can be thousands of dollars. If it's a family of four, a mom and a daughter and a dad and a son, we all know they can't go to the same shelter. They've got to go to separate shelters. Then then you have multiple shelter days. It's somewhere running from $40 to $100 a day. They start adding up. Then they need to take advantage of other community resources. So for that $300 that could have been provided for them to have a lawyer, now society as a whole is spending $10,000. And there's a movement where people are recognizing that and saying we need to stop that, we need to do it a different way, but it's going to take a long time. We will have civil Gideon someday, I would predict, but we won't have it in Ellie Krug's lifetime, unless I get to be a really old lady. So, okay, so.
Address Lo Bono now?
Do you want to address Lo Bono? Yes, that's great. Okay, so, all right, so what I've been talking about here this whole time is the idea that someone can afford a lawyer, and so the system is funneling. How are we going to get a lawyer to that person or get them access to legal advice? And all of that is called pro bono. When legal aid employs a lawyer to assist somebody without charging them, in the larger sense that's pro bono, but those lawyers are being paid by an organization. Pure pro bono is where a lawyer volunteers their time and says, I will represent you and I won't charge you. And I know that I'm going to do that from the beginning to the end. And so, and Minnesota lawyers, over 1,000 lawyers last year donated 50 hours each in pro bono time. That represents, I think, the $27 or $24 million worth of legal time donated to folks. And so, I will put a plug in for my profession, because imagine that Ceridian says, we really like you, but we'd like you to work for 50 hours for free, but you still have to pay your bills, And so, and certainly we like Ceridian, but I mean, if you think about it, donating 50 hours of your time is a significant thing. The unfortunate thing is that we keep going back to the same lawyers and asking, not only 50, will you give us 70? Will you give us 100? And lawyers in Minnesota, as well as in most of the United States, are not obligated to do pro bono. There's an aspiration that you provide 50 hours, but it's not an obligation. Lo bono. Lo bono is not free, but it's below market rate. And so lo bono, if lawyers are charging anywhere between $150 and, oh my God, probably $800 per hour of time. I don't know who could be worth $800, but an hour, but that's okay. And so lo bono would be below market rate. So in Minnesota, lo bono is ranging from somewhere between $35 an hour up to $95 an hour, depending on locale. In Minnesota, the two bar associations that are the largest, so that's the Hennepin Bar Association and the Ramsey Bar Association. They have lawyer referral services. We've talked about that. They each operate a lo bono component to those services, and they charge $55 an hour. Emily and I just came from a board meeting for the Collaborative Community Law Initiative, which will open at the end of this year in St. Paul, which once we do that, you will know about it, which will charge $65 an hour. Now, $65 an hour is a lot of money for people, but it's sure a lot less money than $150 or $200. Yes, Teresa.
Well, how much, so it's $55 an hour. How many hours does a typical case take? So how much do they end up paying in total at the end typically?
Okay, great question. And the answer is, it depends. And it depends on the kind of case. It depends upon how complex it is. In part, it depends upon how difficult the client is. So if you have a client that's calling you every other day, and I've had these clients, I saw this thing on TV. Do you think that this would apply to my case? No. Well, why not? You know, now you're on the phone for 20 minutes. That is more complex than the client that calls you only when you want the client to call them. So, and that gets, you know, so that's the best I can answer it. But low bono, for the most part, every low bono program requires a retainer. And so what is a retainer? It's like a deposit that you put down on the case. But it's not like a rental deposit, because a rental deposit is supposed to be saved until the end of your tenancy, and then the landlord's supposed to give that back to you, less anything for damages, or if you run out, they get to take it as your last month's rent. Attorney retainers work under the principle that you put the money up front, and then the attorney charges their time against the retainer. So you give me $500, let's just say I'm going to charge you $50 low bono. I start billing against that, you're going to get 10 hours of my time. Okay? And the thing about low bono is that A, it's a fairly new concept. B, there are more and more lawyers that are starting to do it. Within the last 2 weeks, I've had lunch with 2 lawyers. One who wants to do low bono bankruptcy, the other who wants to do a low bono family law practice, who have come to me. And this is growing in idea. And lawyers don't have to have an exclusive low bono practice. They can have a practice where they charge clients who can afford more, but that they do their service to the community, some in pro bono and another larger part in low bono. And I'm just going to tell you, lawyers can make a living doing it. It's just the way you watch your expenses, just as with any other business. So, and that's going to be what the collaborative community law firm will be doing, is teaching brand new lawyers on how to run low bono practices, either in a whole or a component part. And I'm really happy to say that this was envisioned by Call for Justice, and it's been facilitated by us, and that it will come to fruition by the end of the year. So stay tuned. All right.
I guess just one little thing about how do lawyers set their fees? Because, I mean, it always seems super expensive, and I don't think people know why it is as expensive as it is.
How do doctors set their fees? You know, I mean,
Yeah.
part of it is about tradition. Part of it is about locale. A large part of it is about locale. So the incidence of a lawyer in the Twin Cities charging, let's say, $200 for a family law case, probably pretty frequent, I would say. But if we went out to Bemidji, or we went out to Alexandria, or we went to another more greater place location in greater Minnesota, those kinds of rates would be far less. Far less often you would see that. And so some of it is based on the clientele that's in the area, what they can afford to pay. You've got a lot of people, more people that can pay $200 in Minneapolis than can in Alexandria. And so it's that. It's also, as I said, tradition and historical nature. I mean, lawyers have charged more because it is a specialized field. What many people don't understand is that there are risks that lawyers take. I mean, I may give Natanya great advice about her case, but she could end up, instead of paying Ellie Krug $500 with a jury, you could end up, a jury says they want to give you, they want to assess a judgment against you for $250,000. And you're going to say, Ellie, you did something wrong to cause that. So there's risk involved with that, so that goes into the cost of it. But I will also tell you that being a lawyer is a lot of work. There's a lot of stress. You guys have stress too with your jobs. No question about it. Everybody has stress. But there's a lot of stress with being an attorney. And some of it is because you can't turn it off. You take on the case, you take on the client, and you go home and it's still with you. And there are a lot of lawyers that wake up at 2 o'clock in the morning because this case or that case or several cases are bothering them. I can attest to that. Yes?
Does any of some of the fees, especially like for the low bono lawyers, or even in a retainer fee, does that include like the filing,
The filing
fees and court fees?
Great question. Great question. And the answer is, it depends. Okay? The retainer usually is for the fees, but when I was in private practice, I would say the retainer is going to be X, and yes, the expenses would come out of the retainer as well as my fee. But other firms and by the way, some nonprofit legal providers, they may help you with a case, but if it involves filing fees or something like that, they may look for you to pay the fees. They may provide you with the lawyer, but they may look for you to pay the fees. Again, it depends on the program. But the kind of fees that we look at is that there is a filing fee. In Minnesota, there's a fee to file a motion. In other states, there are fees associated with depositions. We have our great court reporter, Dan Burton, here, who is our videographer. But there are fees for videographers. Thank goodness Dan donates his time to us, and thank you very much, sir. That is a friend of justice. But if you take a deposition, so a deposition is a very formal interview under oath. We've all seen the court reporters in the courtrooms on TV. Depositions take place in offices for folks of law offices. The court reporter, they charge. They charge by page sometimes, and sometimes those charges can be $3.75, $4 a page, and you know how lawyers can go on and on. So, again, being facetious, and so, yes, expenses they can rack up, and that many times the expenses can be as significant, if not more, than what the lawyer's fees are. And this is why in 1982, when I started practicing law, 25% of all cases that got filed. So, Natanya, if it was 1982, there'd be a 1 in 4 chance that you and I would be in a courtroom, that we would be battling it out in front of a jury. And for me, I wanted to be a trial lawyer. I wanted to stand in front of juries. That was what I wanted. That 1 in 4 chance, that was a really great ratio. That I would have wanted 1 in 2, but 1 in 4 or 1 in 3, but 1 in 4, I would take that. That was 1982. In 2015, less than 2% of cases are going to trial. And why is that? It's because of the costs involved, because of the risk, because you don't know what a jury will do. Can anybody here say McDonald's hot coffee case? And those things, they add up collectively to insurers being afraid, to attorneys being afraid. There's, and you have many attorneys today who don't know how to try a case because they don't have the experience of having gone into the courtroom. On the criminal side, far more trials, because these folks over here, they're going to say, you know what, it looks like I'll go to jail anyway, but I'm going to make the state prove the case. And that reminds me that I also need to talk about burden of proof, and I'm going to insert that parenthetically here, but I want to come back to lo bono, so please, because we're going to end talking about lo bono. Burden of proof. So over here on the criminal side, remember it's about constitutional rights. And so in order to take somebody's liberty away from them on a sustained basis, so we're talking 30 days, we're talking 6 months, we're talking 10 years, we're talking life, the government requires that you prove that the state prove that you committed the crime with a standard of proof that is beyond a reasonable doubt. So beyond a reasonable doubt is like really, 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 we really believe they did it. It doesn't have to be with complete certainty because nobody can do complete absolute certainty. But beyond a reasonable doubt is what really takes a lot of proof about somebody. So many times in a case, you'll see the defense attorney saying, the state hasn't proved its burden. There's still a doubt here. They can't get over this one fact. And that fact is the one that is the element of doubt. And so you need to acquit. In a civil case, the standard of proof is preponderance of the evidence. And essentially in percentages, that is 51%, it's 50.05%, it could be 50.05%. All it has to do is just be a little bit greater than not. And so in civil cases, the kind of proof that wouldn't work in a criminal case can work in a civil case. So everyone here familiar at least with the name O.J. Simpson? O.J. Simpson, standard of proof beyond a reasonable doubt. He had very good lawyers and very bad police officers in terms of their procedures on how they followed things, and their attorneys were able to make a case that the LA police were out after O.J. Simpson and that he didn't commit the crimes. That was criminal, and he got off. He didn't have to go to jail as a result. Over on the civil side, the families of Nicole Simpson and Ron Goldman, they sued O.J. Simpson. It was a civil case. And using the same evidence, and then O.J. Simpson made some really dumb remarks in between the criminal case and the civil case. Over on this side, they were able to get a judgment and millions of dollars worth of a judgment against O.J. Simpson. Same facts for the most part, different burdens of proof. So, all right, back to Lo Bono. And this is the last thing I'm going to talk about because we're running out of time. And in your materials, we have, I've given you sort of a role play as it relates to helping to raise with callers the idea that paying something for their legal fees would help them immensely. So this goes back to Call for Justice beginning in late 2011. Me personally starting to receive calls from some callers from a variety of sources, some sent by 211, but you guys are doing such a great job, but by other organizations. And usually the way the call begins is with the caller saying, hello, this is Sally Schmo. I need a pro bono lawyer. My first question to Sally is, what's the nature of your legal matter? Well, I'm having a problem with my ex and I think we need to go back to family court. And then we'll talk a little bit and it'll be pretty clear to me that she's in family court, there aren't enough family court lawyers, her ability to find a pro bono family law lawyer is going to be greatly restricted. Our Tubman folks here would know that probably very firsthand. And that in all likelihood, she's going to have to navigate the system by herself or go through the pyramid, the unbundled advice. And I didn't even talk about the court self-help centers, which are down lower on the pyramid, where they're open to everybody, but you cannot get legal advice from the court self-help centers. They can help you with forms, but not with legal advice. And then at the bottom of the pyramid, there's nobody there. People are just floating all on their own. But so in my conversation with Sally, it eventually comes around to me asking, okay, I know you want a pro bono lawyer, but can you put your hands on $500 or maybe $600? And half the time I'm hearing from the callers, well, yes, I can. Or I'm hearing, well, no, I can't, but, and then I say next, do you know somebody that can give you $500 or loan it to you $500 or $600? And half the time, I am not exaggerating here, half the time, folks, the caller can either come up with $500 or they can go to someone who has it. And when I tell them, if you have $500 or $600, it will get you from the back of the line, that is where you're searching for lawyers, to the front of the line where you'll be able to access Lo Bono lawyers. People are like, I didn't know that, but now I'm going to do that. And so what I want as part of our training here with 211 is I want to instill in you the sequence that I give you in the training materials. It does not have to be complicated. And you know what? You don't have to sell them on Lo Bono. You don't have to make them come up with $500. Thank God. Okay, but what I want you to do is I want you to plant the seed. And if what's happening in the system right now is if you call up a nonprofit legal provider and you say, I want an attorney, and they say, well, you're not eligible for us, almost none of them are asking, do you have $500? And what I believe, as the executive director of Call for Justice, is that that's a dialogue that we need to start having with the folks who are showing up, who are in legal need. And it's an information gap. It's just, and I'm not exaggerating. Half the people I say that to say, yeah, I can come up with it. So remember what our low bono resources are. For 211, our primary low bono resources are Hennepin County Bar Association, their modest means their family law low bono panel, which they're requiring $500 retainer, a charge at $55 an hour. I heard from the Hennepin Bar Association 2 weeks ago. They are placing every person who calls with a low bono request, they are placing them with a lawyer. That's huge, okay? Our second resource, the Ramsey County Bar Association low fee panel. That is a $600 retainer at $55 an hour against that. And Ramsey will do low bono across the board, not only in family law, they'll do it in bankruptcy, they will do it in real estate issues, they will do it landlord-tenant, they'll do it in OFPs. And the Ramsey lawyers will go outside of Ramsey County. So just because it's Ramsey, they will go outside of Ramsey.
Right.
So make sure your callers know that.
But not the Hennepin ones.
Not that Hennepin will only stay in Hennepin. Although, you know what, I mean, if you can try. I mean, I'm okay, third resource for low bono. Now remember, last week and the week before I've had 2 lawyers come to me with low bono practices. Now these are they're not nonprofit people. I mean, they're lawyers operating their own firms, but doing low bono. Under 211's referral restrictions and referral criteria, you can't make direct referrals to those folks. But remember how we deal with that. Call for Justice has an alternative 211 referral button on its website. Send them to us. Those folks will be listed. And I am positive that as we go forward, we will have more and more low bono resources listed under alternative 211 resources for Call for Justice. And so I can't stress enough about the need to at least raise this. And you can do this in 30 seconds, even if that. But it's important that people understand that this exists because they don't know it. Now, back to Asia's question, what will $500 get you? Will it get you, or maybe that was Teresa who asked, will that get you, all that you need? And the answer is, it depends. And the other answer is, maybe not. But I will tell you this. Natanya, let me ask you a question. Would you want 10 hours of my time or a half hour of my time? 10. You'd want 10. Mm-hmm. And would that be a much bigger help than a half hour?
Absolutely.
Okay. And so if that's what happens, that's what happens. And maybe you can put your hands on another $500 after the first $500. Who knows? But it is far, far better than the bottom of this pyramid. Far better than the bottom of this pyramid where people have nothing. And so I'm also holding our legal resources cheat sheet. Are you guys accessing this and utilizing this at all? I mean, I know you have a computer database that, rivals IBM, but, at any rate, remember that this is on our website. You can refer people to our website. They can download our legal resources cheat sheet, and hopefully it can be of assistance to them. Emily, have I missed anything that I should speak about? Let me just check my notes here. Oh, yes, absolutely. I want to make sure that I remind everyone here, we do have a resource in Minnesota for people up to 200%, Minnesota Legal Advice Online. Who here has referred somebody to Minnesota Legal Advice Online in the last month? Raise your hand. Okay, great. And so, I will share with you, and I don't know if I've shared this fully with you, but I'll share it with you again, and if I have, just bear with me. you remember, 211 and Call for Justice were stakeholders in Minnesota Legal Advice Online. We had Minnesota Legal Advice Online come and train in May of 2014 before they went live. And then they went live in the middle of June. And so from the middle of June until the middle of October, I'd say the first week of October, Minnesota Legal Advice received 447 inquiries from people who had asked questions on legal advice. And remember, it covers everybody up to 200%. There's no issue about assets, it's only about income, and it's a very easy questionnaire for people to get past. And they don't cover bankruptcy or criminal, but they cover everything else. So, from June to October, 447 questions. From June to October, the number of inquiries, the number of referrals by 211, telling people about Minnesota Legal Advice Online, 200. Not every one of those 200 turned into those 447, but I'm going to take credit, and I want you to take credit for at least 100. So if you think that you referred 100 out of 447, that's nearly 25% of a brand new program's participants. That is phenomenal. So continue to remember it. And everybody has the little card in their cubicle about Minnesota Legal Advice Online and Law Help. And let's finally remember how we're doing our referrals. Primary, so that we'll get somebody to talk to a human being that has a legal background, and then backup. We're always going to do primary, Immigrant Law Center, and a backup, lawhelpmn.org, the Court Self-Help Center, or a law library where there would be a clinic. Always, always, primary and backup. All right, anybody have any questions? Okay, well, that will conclude our training this session for United Way 211. This is Ellie Krug, the Executive Director of Call for Justice. I would add that it is, in the time since our last training to now, I've been in Houston, Texas at an American Bar Association mid-year conference to receive an award for Call for Justice for our work in opening access for low-income people. The Lewis M. Brown Award was given to us on February 6th. Happy to report that, and part of that comes to us because of our work with our great friends and collaborators at 211. So we share that together. Please, if you can, please support Call for Justice. We take donations through Razoo or online, and we'll even take a plain old check through the mail. And this concludes our training. Thank you very much.